As always, the views expressed during today's webinar are those of the speakers, not of Strafford, the speakers' firms, or clients, and are not intended to provide legal or tax advice. We have gathered a panel to provide practical guidance to counsel for both borrowers and creditors on student loan debt in bankruptcy, including bankruptcy court treatment of different types of educational loans, bankruptcy code provisions governing student loans, relevant cases, and judicial precedent in all federal circuits, local practices and policies, partial discharge of student loan debt, and specialized treatment of student loan debt in Chapter 7 and Chapter 13. Our panel today includes John Baxter, an attorney with Nelson Mullins Riley in Scarborough. He's joined by Natalie Jean-Baptiste, founder of the law office of Natalie Jean-Baptiste. And rounding out our panel is Detroit bankruptcy lawyer Kurt O'Keefe. John, when you're ready, we'll get started.
Good afternoon, everyone. As was introduced, my name is John Baxter. I'm with Nelson Mullins. I'm in the Nashville office, and I'm sort of tasked this afternoon with providing sort of an overview of student loans and how they interact and are affected in bankruptcy. And then we will move on to Natalie and Kurt to discuss more specifics of that. So just to begin, I'm sure everyone at this presentation is aware that student loans are a major factor in today's economy. As of Q4 2018, total student loan debt was at $1.56 trillion, and total U.S. borrowers were at 44.7 million. So really, it is an issue that touches just about everyone in some way, shape, or form. If you don't have student loans and are under the age of about 60, you either know somebody who does or know somebody who's affected by them. And the delinquency rate for loans that are 90-plus days delinquent is 11.4%. And so it is very much an issue that is on the minds of a lot of people and comes into the bankruptcy Chapter 7 and Chapter 13 sphere quite often. So as I said, I'm kind of going over just the general concept of student loans, sort of a breakdown of the federal versus private student loans. There are typically two types. They fall into the federal or the private bracket. Federal student loans are the most common, and there are a few different kinds. There are 5 different kinds of federal student loans. There are the Perkins loan, which is a need-based loan for applicants with little income and very few assets. With that type of loan, the college is the lender, and so the eligibility for that loan depends both on the student's needs and the availability of funds at the particular college. The perks of the Perkins loan are that there's a low fixed rate of interest and potential loan cancellation for going into certain fields upon graduation, service professions, things of that nature. There are no loan fees associated with that, and there's a longer grace period before repayment is required. Beyond Perkins loans, there are 4 different kinds of federal direct loans. There are direct subsidized loans and direct unsubsidized loans, and direct plus loans, and then direct consolidation loans. And sort of the reason I'm going through all this is just as you address representing clients in bankruptcy and you see that there are student loans, you'll need to know which type of loan it is that you're dealing with, because they all have sort of different facets and different issues related to them. The main difference between subsidized and unsubsidized student loans, as you would guess, is that subsidized direct loans have a subsidy attached to them, so where the government subsidizes the interest on the loan while the student is enrolled at least half time. And so there's no interest charged at that time, and there's a 6-month grace period afterwards before payments need to begin. There's also, if there's a deferral, interest will not be charged during that period of time, but afterwards If the borrower does take a deferral, they may have interest charged. Conversely, unsubsidized loans, you have to begin paying pretty much as soon as the loan amount accrues when you receive the funds, and continue to repay until that is paid off. There are, conversely, with private loans, that would just be what you would expect. You get it from a private lender. One thing I didn't mention with the federal loans is the way you apply for a federal loan is through the free application for federal student aid, which is the FAFSA, and that sort of determines the amount you can get depending on the kind of federal loan you obtain. There are caps for certain loans that you receive, and you have to get those loans every year or every semester, depending on how it's set up. So you don't get one lump sum at the outset. You sort of have to reapply every year. On the other hand, private loans, it's a typical sort of loan application process. You don't have to enter all the information on the FAFSA. So there's no cap like there would be, and you can get it at different times. However, you do need a credit check, and depending on what your credit score is, or if you don't have much credit, then either you wouldn't be eligible or you need a cosigner to sign on, and your interest rates for those will typically be much higher than they would be for federal loans, which are set by the government. So sort of the pros of private loans, like I said, the easy application process, no FAFSA, you can get a cosigner involved, no prepayment penalty a lot of the times, and potentially low fees. But there is, the biggest challenge is just going to be what your credit is when you're applying for those loans. A lot of times, people get student loans if they're going straight into college out of high school at the age of 18, and there's just either no credit history or very minimal credit history, so the interest rates are going to be higher there. With federal loans, the pros really are that they're low loan limits, that there's a potential for forgiveness of the loans depending on what payment plan you enter into and what type of loan you have, whether you enter into a service profession, things of that nature. So there are ways to have student debt forgiven with public loans that you wouldn't get with private loans. Now, it appears that the reality of that situation is that while that is an option, it has not been very well implemented, and it seems that most people who apply for forgiveness at this time are, by and large, not getting that forgiveness. And so that, I know that's an issue that is in the news today, and that is needs to be addressed, because many people are getting to the point where they're at a time when they think that forgiveness is on the table, and then when they apply, they don't get it. So that is an issue. I think that Debtors Council may have some thoughts on that as we go through this. I'm not sure. I haven't run into it much, but I'm betting Natalie and Kurt have seen that some in their practice, or may be able to discuss that more. And so with that understanding sort of just the general student loan atmosphere, this slide has a list of who the major servicers are. Navient, Great Lakes, Nelnet, those are going to be the players that you see most often as servicers. There are more on this list and more not included, but as you represent clients in bankruptcy and see those creditors' names, you'll know that they are related to student loans. So sort of turning to bankruptcy, one interesting facet of student loans is that they are not, educational loans is how they're typically referred to, and they are not defined in Section 101 of the Bankruptcy Code. I know typically when I go looking for statutory definitions to understand sort of the field we're playing on, I'll go to 101 and see how the code defines it, but there is no definition of educational loan within 101. And so really Section 523A8, which deals with dischargeability of loans or of debts, is where the education loan and student loan forgiveness or discharge issues really arise. And so the language of that, I'm just going to read it because statutory language is important. A discharge under Section 727, 1141, 1228A, 1228B, or 1328B of this title does not discharge an individual debtor from any debt, A, unless accepting such debt from discharge under this paragraph would impose an undue hardship on the debtor and the debtor's dependents for A1, an educational benefit, overpayment, or loan made, insured, or guaranteed by a governmental unit, or made under any program funded in whole or in part by a governmental unit or nonprofit institution, or 2, an obligation to repay funds as an educational benefit, scholarship, or stipend, or any other educational loan that is qualified education loan as defined in Section 221D1 of the Internal Revenue Code of 1986 incurred by a debtor who is an individual. And so essentially that section 528 or 523A8 covers 3 different types of loans. There's the qualified education loan defined by the Revenue Code, an educational benefit overpayment or loan that is typically, so payments under the GI Bill above the amount needed for tuition would fall under that category, something like that, or an obligation to repay funds received as an educational benefit, scholarship, or stipend. And so that definition is important because as debtors move for discharge and adversary proceedings to have their student loans debts discharged, one of the first questions that needs to be addressed on both sides is whether or not the loans fall within what constitutes an educational loan under 523A8. A lot of the times that's not a question, and you'll know, I mean, most direct student loans from the government, there won't really be much of an argument on the creditor side to say this isn't an educational loan. So it's a case by case, but there are situations where on the private side, if somebody loans a student X amount of money to pay for rent for while they're in school, that could be questionably a educational loan for the benefit of the student and its education or not. One important thing to look at as well is whether or not, or who actually the loan was given to, and whether there was a guarantor or a cosigner on the loan. The majority of circuits hold that 523A8 applies to parents and guarantors and co-obligors as well, but there have been some cases, I have on the slide here, the In re Prior case from the Bankruptcy Western District of Tennessee, that the co-maker of a student loan in that case was not the student who received the educational training and was not covered by the discharge exception. So those loans were eligible for discharge. I believe in that case, if I remember correctly, it was a training class for I can't remember now that I'm trying to recall the case without it in front of me. But it was some sort of vocational training, and I think that there was a scholarship that was provided to someone that wasn't actually the student. No, you know what? I'm not going to try and recite the facts without in front of me because I'm just going to confuse everyone. So part of the reason that I was going through the private versus federal loans is that how the loan is treated and whether it's private or federal can impact the dischargeability under 523A8. And there was actually a recent case in Oregon that I have cited here. ABI did a write-up on it as well, sort of highlighting how this fight takes place and how in this particular case the debtor had a substantial amount of federal loans and reached a settlement with the federal loan servicer to allow those debts to remain and enter into some sort of alternative payment structure, maybe lowering her loans payments on a monthly basis. But the debtor could not reach the same agreement with the private loans, and so that went to a full adversary proceeding hearing, and the court ultimately held that the federal or the private loans that were at issue at the adversary proceeding were dischargeable because they would cause an undue hardship. I know Natalie's going to get more into the weeds of the Brunner test and how those fights are done, but the primary question is whether or not being forced to continue to pay the loans because they're non-dischargeable under 523A8 would cause an undue hardship on the debtor. That's the language of the statute. And so the court there held that because really the private loans, they had all matured at this point, and they'd been accelerated. And so the creditor came in and said, look, we're willing to work on some sort of payment plan, a deferral. We're not going to charge her everything all at once. But the court said, I understand what you're saying, but really that's just purely at your discretion. And you have the authority, creditor, if you wanted to come back later on and say, no, I want this all paid, to demand it. And because of the amount of money that this debtor has on her monthly income, we think that it is going to be an undue hardship regardless. And so they're discharging all that debt. What's interesting about that case is that the debtor in that case was actually an attorney. And she was working, the court found that her current employment was the maximum level of payment that she was going to receive, and that she wasn't going to be able to pay these debts off without it substantially hindering her ability to move forward with her life. So the court, because they were private loans and because the private creditor had the options that it had to collect and to garnish wages and things like that, the court was ultimately able to determine that there was an undue hardship there. And so that sort of highlights where the major points of dispute are going to be between the debtors and the creditors. Like I said, preliminary question, whether or not it fits the definition of an educational loan, then determining whether or not it's federal or private. Another major issue is what is the purpose of the loan. If you can argue, if the debtor can argue that the loan was not provided for an educational purpose, then the debtor may be able to get outside the scope of the non-dischargeability, the exception to discharge under 523A8. And then there's also the question of the obligor or co-maker of the loan. One issue that I know is important for creditors as they are dealing with adversary proceedings and dischargeability of debts, the one thing that is probably most critical, and we'll probably get more into practical guidance and things like that as the presentation goes on, but from a creditor side, one of the first things that you probably want to do is get discovery out as quickly as possible, either prior to the adversary proceeding through Rule 2004, or more likely when the adversary proceeding is filed, because really it's going to come down to determining whether or not the payment obligations the debtor has on a monthly basis are substantial enough to where there's a chance for the undue hardship to be shown. Because really, that's where the nuts and bolts of it is in seeing how much this particular obligation is versus the other obligations that the debtor has on a monthly basis, whether they are necessities or I don't want to say frivolities, but no other word is coming to me. Necessities or things or exposable income in some other way. So if the creditor is trying to show that the debtor has more funds available to him or her than they are alleging, whether that be because they list on their documents that they pay $500 in transportation costs per month, but really their commute to work is only a mile and a half each way, and so they're only filling up their gas tank twice a month. Things like that is where the creditor is going to want to try and get some information so that they can come to the table and have the necessary ammunition to argue the applicability of the exception to discharge in the Brunner fight. And so with that, I will pass it on to Natalie as she discusses sort of the process for discharge.
Good afternoon, everyone. My name is Natalie Jean-Baptiste. I'm a solo practitioner on Long Island, New York, where I specialize in student loan debt and bankruptcy. I actually was my first client in 2013. I filed for bankruptcy and brought my own adversary proceeding. My background prior to getting into bankruptcy was in the entertainment industry. I was a music industry lawyer, and I had no bankruptcy experience, no litigation experience. But when I was teaching myself bankruptcy law, really out of necessity because I couldn't afford the legal fees, I stumbled upon the undue hardship rule. And when I read, the requirements of the Brunner test, I said to myself, well, this sounds like me. And I naively, endeavored to bring this adversary proceeding. And had I known how difficult it was going to be, I probably wouldn't have, brought the adversary proceeding or even tried. But since, when I brought it and I was already in it, I saw it through. The case ended up settling before we went to trial. I owed about $156,000 on my federal student loans, and really on the eve of trial, or we were about to set this, the trial date, I was able to settle with ECMC for $36,000. So after my success in my own case, I said, well, there are other people out there struggling with student loans, and I really developed a passion for bankruptcy and for helping student loan borrowers. So I've been doing this for the last 6 years now, and, initially I was like, well, maybe my case was a fluke, but I've been able to successfully, settle or bring to trial or get discharges for other clients as well. So that's just a bit of my background, so you guys understand that the undue hardship is near and dear to my heart. And so I'm going to get into what it takes to establish undue hardship. So, the most prominent test for undue hardship is what's called the Brunner test. And it's adopted by all circuits except for the First and Eighth Circuit. And the burden of proof is on the debtor to establish undue hardship. So there are three prongs to the Brunner test. So the first is that, the debtor can't, based on their current income and expenses, maintain a minimal standard of living for themselves and their dependents if they were forced to repay the loans. The second is, are there additional circumstances that indicate that the state of affairs is likely to persist for a significant portion of the repayment period? And third is whether the debtor has made good faith efforts to repay the loans. So all three of these prongs need to be established and proved by the debtor in order to be eligible for discharge. The other test that is used is called the totality of the circumstances test. This is less prominent. It's only used in the Eighth Circuit and some courts in the First Circuit. And the bankruptcy court considers the debtor's past, present, and reasonably reliable future financial resources. 2, a calculation of the debtor's and her dependents' reasonable and necessary living expenses. And 3, any other relevant facts and circumstances surrounding each particular case. The totality of the circumstances test is a little bit more relaxed than the Brunner test, and it's more favorable for the debtor, but, as you can see, Brunner is more prominent and used by most courts. And so let's look at some of the factors in the totality of the circumstances test. Some people may practice in jurisdictions that use this test. So we look at multiple factors, including total present and future incapacity to pay debt not in the debtor's control, good faith effort to negotiate a deferment or forbearance, whether there is a long-term hardship, whether the debtor made payments on the loan, permanent or long-term disability, and can the debtor find gainful employment in her area of study, the efforts to maximize income and minimize living expenses, and also was the dominant purpose of the bankruptcy to discharge a student loan, or were there other debts involved as well, and the ratio of student loan debt to total debt. Okay, so let me get into applying the Brunner test, and this is what I use in my jurisdiction, and we'll go through the three prongs. So the minimal standard of living is the first step. So you want to look at the debtor's expenses. So when the person initially files for bankruptcy, they have to fill out the income and expense schedules. That's part of the main case. Just to clear up, so when a person files for bankruptcy, if they want to get rid of their student loans, it's not automatic. It's a separate process called the adversary proceeding. That it's a complaint, and it's basically litigation of a separate case in the bankruptcy court. But in the first step is when the person files for bankruptcy, they have to fill out Schedule I and J. Schedule I is the debtor's monthly income, and Schedule J is their monthly expenses. So that's always going to be a point of reference, but many times when the debtor files, the trial or discovery is happening months or even years later. Also, it's important to point out that, if someone files for bankruptcy, and I get clients like this too, who the person filed for bankruptcy 3 years ago, and their attorney told them, oh, there's nothing you could do about student loans. And then they hear about me, they come to me, and they say, well, what can I do? So in that instance, you would file a motion to reopen the case and then bring the adversary proceeding. So when you're bringing the adversary proceeding, if you're looking at Schedule I and J in the main bankruptcy case, that was the debtor's financial picture 3 years ago, and it may not necessarily be what the debtor's financial picture is currently. So it's a good starting point, but you'll through discovery, they're going to the adversary or the creditor or the student loan holder is going to request financial records. But anyway, let's get back to what are the elements of the minimal standard of living. So you want to, of course, cover decent shelter and utilities, food, personal products, the vehicles, the car needs to be maintained, insured, registered, health insurance, or the ability to pay for medical and dental expenses when they arise, and at least a small amount of life insurance and funds for recreation. So this comes from the Ivory case, the 2001 case that outlines what the basic necessities are. And this is, basically the categories that are outlined in Schedule J as well when you file the initial bankruptcy and the debtor is listing their monthly expenses. So all right, so this slide just lists a few cases that touch on the minimal standard of living. So the first example, the debtor satisfied the minimal standard of living because she had $400 of disposable income, but the payment of her student loans was over $350. So the court found that would be a hardship. The second, in the Traversa case, the debtor satisfied the minimal standard of living because debtor had been unemployed for years, lived with his mother, and received SSI. In the third example, the debtor failed to satisfy the minimal standard of living factor because the debtor had over $1,272 of disposable income, and his student loan payment was only $808, and that left him a surplus of $464. So let's look at what, again, just a list of what reasonable and necessary expenses are. Food, housing, utilities, the basic communication. So for that, it's either a landline phone or, the most basic cell phone plan. If there's anything like unlimited data, the court is going to scrutinize that, and so is the adversary. Necessary medical and dental expenses, necessary insurance, transportation, child care, and of course child support or alimony has to be factored into the debtor's budget. So luxuries, when you're litigating in undue hardship, the adversary or the student loan counsel is always going to scrutinize every expense that the debtor has. So typically, you have to turn over about 5 years of the debtor's bank statements. So every line is going to be looked at. So luxuries are, what the court sometimes can deem luxuries, or the student loan or the creditors can deem luxuries, include dining out. So anytime you see a restaurant charge there, gym memberships, premium cable, premium cell phone services, salon, spa, cosmetics. I've had clients sitting in depositions where, my adversary will ask her about, Sephora or, European Wax Center. Every time it comes up, and the debtor, does get frustrated because it is annoying, but anything like that is going to be looked at as disposable income that the debtor would otherwise have to pay their student loan. Concert tickets, anytime, going on vacation, so flights, hotels, even alcohol and cigarettes. So the adversary will be quick to point out any trips to the liquor store to show that this person, has the money to pay their student loan. And it's almost, it's not just a question of their finances. It's like their morality is almost being called into question. Well, why can't you pay your student loan? It's because you're, spending your money at the liquor store, things like that. So I always prepare my clients, and I let them know, going into a deposition or going into the trial, that my adversary is going to make them look like a deadbeat and an irresponsible person. But at the end of the day, the person who is, going to Sephora or going, has a gym membership, their living circumstances are not ideal. They're staying with family, they still live in their childhood home, or they have a special arrangement with roommates, or whatever it is that allows them just that little bit of money to have that freedom to do certain little things that, the court may look at as a luxury. All right, so let's look at also the additional circumstances. So this is the second prong of the Brunner test, and so it's looking at whether or not the circumstances that are happening currently are likely to continue, and for how long. It can't just be a temporary setback. There has to be evidence that this is going to, last for a significant portion of the repayment period. So that's also a question, like, what is the repayment period? And, typically when Brunner was decided, the typical repayment period for a student loan was 10 years. But these days, since the student loan crisis has gotten so out of hand, the federal government has forgiveness programs, income-driven repayment programs that can last up to, anywhere between 20, 25, 30 years. So that repayment period is such a long time that it's hard to really predict how, what the circumstances are going to be for that prolonged period of time. And, in a 2009 case in Ray Nyes, it's asking for a certainty of hopelessness. So I think that, is flawed the certainty of hopelessness test, it's like, how can you, it's like asking the debtor to prove a negative. Like, how do you prove that something, that nothing's going to happen, or your situation's not going to turn around? Other factors that are looked at for the additional circumstances prong are, the debtor's age. If they have children, it has their earning capacity peaked, so they'll look at what is their past income, what is the potential, the earning potential that the person has. Are they, did they actually finish their degree? Do they have the degree that they need to, do they have the skills that they need to be able to get a better paying job? And again, like I said, the original loan repayment, I always argue that the period that we should be looking at is 10 years, not the 25 years. Also, going back to the minimal standard of living, when you're arguing that the debtor does not have enough to make payments on the loans, I always argue that we should look at what is the standard payment. And when you're litigating federal student loans, the adversary is always going to argue to the court that, well, if the debtor just enrolled in the income-driven repayment plan, their payment could be zero, or they could pay $100 a month for 20 or 25 years, and then the balance would be forgiven. And I always argue that, no, we have to look at what the standard payment would be and how that's going to affect the debtor's budget. So if their standard payment is $800, but they only have, $200 of disposable income, I argue that the first prong of the Brunner test has been satisfied. So it goes back and forth, and, most of my cases settle, thankfully, and I don't have to take it all the way to trial, but that's always a point of contention in the first prong. All right, so let's just look at a couple more examples that address the second prong of the Brunner test. So in the first example, the debtor satisfied the additional circumstances factor because she was 64 years old, worked on an assembly line for 12 years, and never completed her college education. In the second one, the debtor satisfied the additional circumstances factor because he suffered from severe bipolar disorder. And in the Traversa case, the debtor failed to satisfy the additional circumstances factor because although debtor suffered from depression, sleeping disorders, ADHD, and bipolar disorder, the debtor's condition improved with medication. Okay, so good faith is the last prong of the Brunner test, and there is no textual basis in the code for this. This is just one of the factors that the court decided in Brunner, and they look at the debtor's efforts to maximize their income and their, also past career decisions. Bad for ministers, artists, musicians, public interest lawyers, because the court will ask, well, why, or the adversary will ask, well, why haven't you, pursued a different career path, and you could have, gone into this field and made more money, things like that. So looking at, it's almost, again, just, questioning, life choices, morality, why haven't you, they look at, are you trying as hard as you can to maximize your income and also minimize your expenses? So, if the debtor, is driving a car, like, because I'm in New York City, or I practice on Long Island, but I have a lot of New York City clients. So if the debtor has a car when, they could theoretically take the subway, they almost have to justify the reason why they have a car, because the adversary will bring up in the deposition, well, why can't you take the subway? And usually the person has a good reason because of the shift they work, or they have to pick up their kid, or whatever it is. But things like that, so they look at why haven't you, or, the choices to go out to eat instead of bringing your lunch to work, things like that. Again, the court has, the courts have decided that being too poor to make payments is not bad faith. So even if the debtor has never made a payment, which happens, the loan has either been in deferment or forbearance for a significant amount of time. And when the person runs out of forbearance time and they're in danger of defaulting, that's when, or that they've already defaulted, that's when they potentially will go and file for bankruptcy. So when the good faith argument comes up, the adversary will bring up and say, well, this debtor has never made a payment on the loan. And I'll argue that the debtor has struggled over the years, and looking back at their budget, if you go back 3 years or 5 years, you can see that there was never enough disposable income for the person to make any substantial payments on the loan, so that can't, deny deny good faith based on that. All right, so let's talk about partial discharge. So the courts are divided about whether they have the authority to discharge a portion of a student loan while declaring the remainder non-dischargeable. So there are 3 approaches here. So the strict approach is an all-or-nothing approach. So the courts, conclude that the 523A8 contains no statutory language that would authorize a partial discharge of a student loan, and that the authorizing partial discharge leads to unpredictability and lack of uniformity. So this is either the loan is dischargeable or it's not, period. There's no gray area there. I always argue that the flexible approach. So I argue that the portion of the student debt that's causing the hardship can be discharged, while the remainder, they can repay the remaining portion. So whatever would work for the debtor's budget would be acceptable to discharge at least a portion of it. And if you're arguing for partial discharge, the debtor has to satisfy the Brunner test or the totality of the circumstance standard as to the discharge portion. So it's, even if they're going for just the partial discharge, each of the prongs of the Brunner test have to be addressed and proven by the debtor in order to qualify for that. And then there's the hybrid approach where it forbids the partial discharge of a single loan, but it allows debtors who hold multiple loans to discharge some of those loans but not others. So, many student loan borrowers have several different loans. So with the hybrid approach, it's approached on a loan-by-loan basis. Okay, and like I addressed before, the income-driven repayment program is, always an issue that comes up when we're looking at proving undue hardship. So in the Mosley case, the court decided that participation in the income-driven repayment plan is not required to establish an undue hardship. And also, in the Durrani case, the fact that the debtor can afford the monthly income contingent repayment is not dispositive as to whether she can maintain a minimal standard of living while repaying her student loan. All right, so that's pretty much it for undue hardship. So I'm going to turn it over to Kurt, and he can take it from here.
Thanks, Natalie. I want everyone to know that even though this is a webinar, I have appropriate CI and season tax on everyone. I'm the dinosaur on the panel. I go back to actually before Brunner, when I started, basically when the bankruptcy code was rolled out. It was loans were dischargeable if it was 5 years running forbearance payment, last payment until you filed the bankruptcy case. There were no Schedule I or J yet, and that is when the Brunner debtor attorney made this horrible case law by overreaching. The client could have waited a few more years. Chargeable. And the appellate courts have really ignored the means test and the other. Brunner, as Natalie said, the So I'm going to try to balance my presentation in terms of it is going against the government. It's usually they're not playing with their money. Versus they will get discovery and closed, and you need to pay out. I'll start off with some of the resources that are helpful. The National Association of Consumer Advocates group with a website. I'm a member about this manual Bible on student loan. If you're going to get into it's just very, very underserved. Better side, and then you'll have a listserv if you're. Joshua Cohn is a friend of mine. He doesn't know I'm throwing the slide up. The student loan lawyer. He's now in Vermont. This is all these. Then he has his website, and if you've gone to the seminar, you'll be one of the attorneys. And there's a listserv there. There's resources for you all over the country. A lot of some terms like collegiate trust cover rates in multiple. Own blog. DOE, I used to say Department of Education DOE, but I guess that's Department of Energy. So I've yet to meet a client who knew what loans they owed, if they were private, if they were government, when they got them. And of course on the bankruptcy side of the fence, they tell about the debts and they don't open the on. So there's some of the find out all the government loans their client can't. I don't want to do that. They could give you the private information, but I don't want to do that because I want them to problem on the attorney, and then he'll let capable able to come up with that. So, Chapter 13. Laughing at Natalie's case that talked about, well, you don't want partial discharge because then you don't. Especially in the 13, the trustees treat these differently. Judges treat these cases differently. There's no uniform over there. Widely varies. So in our case, Chapter 13 trustees in Detroit changed their policy, allow for these. Ed Boltz is now president of the National. Countered is that the Department of Education is not filing or having claims filed because it's hostile and through Chapter 13 mandated over program like in the middle of Florida. And to deprive, this is not an adversary case, but this is just of policy things that USED, United States Education Department, they like the administrative setup, the bureaucracy they have. They want to and they have the rest. I want to make the comment too that we're lawyers and we deal with the legal system. Much of this is just politically driven. The Department of Education can change their policy in the terms of how aggressive they want to be in these cases. Requires them to they were to agree standards the courts have imposed. Expenses and so on. That and happened times, especially regarding federal government. Something about the Chapter 13 cases and doing a student there is getting paid for these cases is a trick because, of course, the client is already in bankruptcy court. And in a good case, I have it serendipitously. Competent attorney had filed 2 Chapter 13s, paid a bunch of payments, but the attorney didn't scheduling debts and didn't know how to file. she actually had over $8,000 left from those two cases. Right, the judges say, third case to be confirmed, you've got to pay the trustee that. Put in part of the plan to hold $5,000 of that, any fees, Chapter 13 adversary. So when you're looking at a Chapter 13 client, possibly maybe they could save some money and pay you off the bat in the plan, and you put that in, get the court's permission, of course, to be able to hold that, to be able to finance litigating Chapter 13. Have the creditor on hold because of the automatic stay as far as facing you, possibly in a very trustee judge dependent. Possibly you can information out for a year, the debtor pays some money, and you're disclosing to the court that in order for this work really needs relief. Those are some of the things in the 13th. Timing, again, the case law is all over, of course. Courts say you have to do it right away. Some say you have to wait till the end. No statutory basis. Timing in terms of when you would bring an adversary in a 13 cases, but check if there's been a holding that's so it's the same process as the Chapter 7. You have to file a separate adversary. And I mentioned, we talked about the schedules, and have a student loan issue, just look at that. Not just your usual. You're going to have that possibly with your schedules. Scheduling this as a student loan or educational loan, and you come back with an adversary, the creditor will just say, well, you've already stated it's an education. Most of the courts, if not all, have held the burden is on the creditor to show that it is. First adversary I filed, the attorney came in with, here's the, I only noted that was I and J schedules that were 2 years old. My argument would be if you're in a 7, owner income base standard of living should in the so yes, we talked about the timing. So this is something that I do want to point out, and Natalie's talking about having success and getting settlement. A lot of this bad case law that we have in the pro per debtors. Oops, sorry, I didn't know my audio was bad. Hold the phone closer. A lot of the bad case law comes from pro per debtors. The cases with attorneys do a lot better. And again, a lot of this depends on the judges that you're dealing with. But I encourage people, and I'm sure because you're listening, that you're into this field of practice. The government will discourage you. They will say, we're going to bring tons of discovery. We're going to overload you. But don't let that discourage you with the right case and the right facts. It's very, very fact-driven area of the law. So some of the side issues with a proof of claim, there's a proof of claim on a case I have with the Chapter 7 and a purported student loan debt on a private debt, and I filed an objection to the proof of claim, and it was granted. So in my view, and there's this one case that supports this, that's issue preclusion. We used to say collateral estoppel or res judicata as to whether that's a student loan debt, so that you don't have an adversary there, but you would have a ruling from a bankruptcy court that that debt is not owed to that entity, and that should result in a win if there's a state court case pursued against your client post-bankruptcy. So the main private lenders I see litigating are the National Collegiate Trust, which is in a couple of Natalie's sites, and Unomics, and they have trouble connecting the dots. The case I had with Unomics, they dropped it. They agreed to dismiss it. I had a NCT case where, well, different cases. There are 15 different trusts, and they filed 5 in Michigan. The district court, state courts have the lower jurisdictional amount under $25,000. So we had 4 circuit court cases over that because each trust had to file its own lawsuit. That particular client had filed a bankruptcy years earlier with a different attorney, and NCT filed a single proof of claim for all 9 of these loans under the 3 letters NCT. So that should have precluded the lawsuit by 9 separate entities because there was no transfer claimed by NCT after the Chapter 13 before the state court suits were brought. And in this situation in the district court, there were 2 judges, and one of them ruled in my favor and one of them ruled against me. So watch the claims, and if your client comes in and they file a private prior bankruptcy, as Natalie said, you can file these later. There's a case in which the debtor filed the student loan adversary 14 years after the bankruptcy. Not sure why a new bankruptcy wouldn't have been used. Now, some courts have said, no, you can't file now claiming a hardship based on something that happened to you after the bankruptcy. But most of the courts have allowed that you can go through and come back later. And one court even said, well, you don't have to file a motion to reopen. That's just administrative. There's no deadline on filing the adversary. So you can file that adversary at any time. So one of the topics we asked to cover was, is the law going to change? And I believe that it will. The ABI had a long study. They did hearings all over the country with trustees, debtor attorneys, creditor attorneys, judges involved. And I have a link to what their specifics are. The National Association of Consumer Bankruptcy Attorneys, which I am a member, has an extreme bill which says just make it like credit card debt and other unsecured debt. So I don't think that will get any traction. So there, this slide is the link to the ABI study. The ABI, it does have some lobbying presence. They do a lot better than the National Association of Consumer Bankruptcy Attorneys. We do have a high-powered Washington lobbyist lawyer that volunteers some time for us. But Ricardo Kilpatrick was at the Detroit seminar here last month and indicated that he is getting some traction with the Congress. He actually said when you get them in their office, they're all for it, but they're afraid to come out in public and take a stand. And that, for those of you that have any knowledge about politics or dealt with politics at all, that seems to be the case. My slides seem to be stuck on my screen. But at this point in time, if the moderator would describe the process for questions, and then I'll go into some more topics on the 3 cases I put on my last slide. Hello? 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 Okay, there's the slide. Thank you.
One recommendation, this is John, before we go into the war stories and these cases and questions,
yes,
it might be beneficial for you to sort of rehash some of the grounds in those first few slides because your audio was pretty spotty, and I'm not sure if we got the benefit of all your wisdom.
I didn't see that. My apologies. You know, it's a landline. I'm at my mother's place because I don't have a landline. Well, in terms of the links and the resources, I think are kind of self-explanatory. The advantages in the Chapter 13, you have the stay and your client's protected, you can be, depending on what your trustees and judges allow, you can be building a fund with the Chapter 13 trustee to get paid, which is a cases, of course. And possibly you could have another source or a relative or some funds that the debtor has before they file that with court approval you can hold in your trust account as a source to be paid. You have to file for the fee application in Chapter 13. You have to have the court's approval, but it's able to do that in that good case. The things about the adversaries, too, in general, in terms of we do have the partial discharge in the Sixth Circuit, but there's flexibility available in that Department of Education context in an adversary that you don't see when you're outside the bankruptcy court. And Natalie talked about settling a lot of the cases. So you can get the beginning payment extended, you can get the interest rate lowered, even if you're not getting a lot cut off the balance. And let me talk about the IBRs, the income-based repayment type things. Now, a lot of the courts, it seems to me they're looking for an easy out, and they want you to do this. It's been mentioned, the creditors will say, well, you could get the IBR and pay $0 or pay $10 a month. ECMC, which ends up defending most of these, not process an income-based while an adversary is pending. So you have to stipulate to draw your adversary, then do the income-based repayment plan. And I think that's another advantage of Chapter 13, because you're in the 13, and in the good case there's all kinds of pleadings and law, and that's why I put the case numbers in there so that trustee changed her policy while the adversary was pending. And if we had an IBR that would work, it would refile the adversary because of the tax consequences that client owes over $250,000. It seems clear that Congress was asleep when they set these programs up and did not consider this tax ability, but it's cancellation of debt income, the way the law stands. No one has finished one yet because they're relatively. So I think it's better if you can be in the 13 and apply for it and come back. And my argument is, look, the government says they can't afford it. They're calculated at $0 per month. You still have the Brunner issue of will this situation persist? Again, it's very fact-driven. And in my case, just like a country music song, a 67-year-old grandmother who custody of 3 grandchildren at the age of 10 because of the drug use of because she has Strafford loans, different income-based repayment plan. Another advantage in adversaries that we're looking at not necessarily wiping everything out. It can be a victory for the client. I had a client with $525,000 of government loans, 500,000 government loans, 25,000 private, but the private was suing. Filed a student loan adversary against all of the defendants, and the private loan looked at it and said, we give up. We'll stipulate to a discharge. At that point, the client then is eligible for, all the student loans are eligible for the income-based repayment. So it wouldn't work, even just a $25,000 private loan, but if they have a judgment and they're garnishing, because the income-based repayment plans do not consider private student loan payments, that just government. That's how the bureaucracy operates. In that case, we just withdrew the adversary because she would be able to go through the government payment program. So that Dell case, horror stories, that's someone that we filed the adversary 2 years later. In terms of sources of being able to get paid for doing the work, adversary, we had a tax run in between. Also, the student loan servicer is subject to the Fair Debt Collection Practices Act. We were able to actually settle an FDCPA case. There was enough money, and I'm not charging a lot of money on these That was a client that's living in the parents' basement that had the out-of-state tuition. 20 program after 9/11, they said you could free any being an emergency manager, and all the cities will want one, so on. But we were able to get where it works for the client. So the point is to get somewhere that Chandler case above there had some private and some public, and then I find the private are a little more flexible in the adversary situation, issues where they don't have the income-based repayment plan. Courts know that, as some of the police cases are aware that anything they do would just be voluntary. One I have going now, the Wilson case, another country music song of the child when she was 14, at bipolar and disabling ailments, has received the total permanent disability from the government loans, and there's a couple $100,000 of private loans left. Filed the adversary against Navient and NCT. Navient looked at the information discharge, so I have a trial. NCT, I'm not sure why they're still fighting it, but they're fighting. Good case is the one with the woman that had fund from the prior botched Chapter 13. And there's a lot of good information in the case because we failed on the summary judgment motion. The trustee thought I shouldn't get paid because I hadn't won the case. So there's good, fortunately for me, decision on fees in Chapter 13 in terms of the benefit debtor test. Private student loan adversaries. Private student loan adversaries are like everything else. They have no rhyme or reason that I can find. National Collegiate Trust outsources everything. On John's list of servicers, he had AES. That is a company that services the private loans. Joshua tells me that the strategy in the Northeast states, issue with the National Collegiate Trust, state court, suitable. He has his client file a bankruptcy because the NCT bankruptcy law firm is different, gives better settlements. State court firm they hire. But it's hard to pin down anything. Now, say the case I have going with NCT now, I don't see, nothing is 100%, but I don't know how they can tell the woman can't get a job, multiple ailments, Social Security, not ever getting back to work. They're still fighting it. I can't really explain any private student loan strategies or consistency across the country. I did want to ask Natalie if she has any other information or tips on aid for bringing, whether you do them in Chapter 13s at all.
No, most of the ones I bring are in Chapter 7 because most of my debtors don't have enough disposable income to put into a plan. So Chapter 7 are pretty much the bulk of my work.
Yeah, is there any trick to getting paid, or do you take payments over time later? Or
I take payments over time, and to be honest with you, I charge a fraction of what I should be charging because for me it's more of a passion project. This is something I'm really passionate about, making changes, and just the more cases that are filed, the more attention student loans are getting. I think eventually it'll pay off. Some of these cases should be $10,000 up front, but I'll take like a $2,500 retainer and then put them on a payment plan. Like, I really try to work with my clients to just, because if I realize they have a strong case, I don't want to turn it away on the money, because for me, I'll make the money in another case, from another case, from my just regular bankruptcy work rather than the adversary proceeding. So you're right. Chapter 13 is a good way to get paid or to ensure that you'll get paid. but it makes more sense, especially, you know, if the claim is hardship, that to file a Chapter 7, in my opinion.
Right, right. Well, yeah, you have the hardship either way, and then in the 13, it depends on what you're paying. In the good case, the debtor lived in a horrible area in Detroit with these kids and just left that house, cashed in a retirement account, and bought a new house free and clear, and didn't pay tax on the retirement. We're dealing with a $80,000 IRS lien on the house that has to be paid in the 13. So it's not really disposable income.
Right.
Disposable income that would be available. Plus, she's like 68 years old now. So these are they're very fact driven. I mean, I get calls from kids that are 30, 28, and they just realized they make a decent living and they're paying the loans, but they can't buy a house and they can't take a trip to Europe and they can't take a vacation. And those people you can't help. It's not that you can help everyone. If they're in
and I mean, I do have some young clients, you know, in their 30s who I've been able to help with private student loans because, you know, even if it's not necessarily a hardship or their hardship claim is weak, you know, if the private lender can't prove that it's in fact an educational loan, because remember the initial burden of proof is on the creditor to show the court that it is in fact an educational loan that was used for qualified education expenses. So I've been successful in settling, like getting great settlements on private student loans.
Well, they're playing with their own money. So the government, whether they get paid or not, it doesn't affect that law firm or the bureaucracy or the government. But the private lender should be able to take a realistic look at what's going on. You may have a statute of limitations defense. I do on that Wilson case. Other state court possible defenses that don't apply federal loans. And I want to ask John, so what can we do on the debtor side to make a case, and what's going to impress you and your clients the way that we can present one of these cases?
Really, I mean, I think what you're talking about, I think you hit the nail on the head sort of with private lenders are playing with their own money. And so typically in my experience with lenders, they understand that to a degree they have the upper hand as far as the case law and the Brunner standard, but at the same time we're dealing with people with limited income with, I mean, they're in Chapter 13 or Chapter 7 for a reason. And so, I mean, I think part of the reason I think Natalie's had so much success with settling private student loan cases is because I think both sides have an incentive in that case more than the governmental cases to try and get out of it without running up costs on the creditor side, because creditors' attorneys are hourly. Every 6 minutes we're dinging them for something. They very much take a cost-benefit analysis and recognize a lot of the times that the chances of getting paid in full in a lot of cases are narrow, and so settlement is a good option. I see we have a question from Christy Arkovich. I hope I pronounced that correctly, Christy, in Tampa. I believe we have a support person needs to read some information before we can answer questions from the audience.
Okay, thank you, speakers, for your valuable insights today. A brief announcement. New York and Kansas states require you record and report the following code to obtain CLE credits for the live or recorded version of this CLE webinar. If you will be requesting CLE credits for this seminar, please write this code down. The code is PLFBC. That's T like Tango, L like Lima, F like Foxtrot, B like Bravo, C like Charlie, B like Bravo. Again, the code is TLFEEE. Now onto our live question and answer session. Listeners can ask our speakers any question relevant to today's topic. You may email questions to bankruptcylaw@stratfordpub.com or submit questions by typing your question into the Q&A box at the right side of your screen and pressing enter. You may also ask questions by telephone. To do so, press *1 on your touch-tone phone. Again, that's *1. And if for any reason you decide not to ask your question, you can press *1 again to exit the question queue. After you press *1, when it is your turn, I will announce first name and city registered for your location. If you'd like to identify yourself further, please do so. If you're asking your question by phone, please turn off the sound on your desktop. And yes, the first question that we have is from Christy in Tampa, and she says, we've been filing a lot of private student loan adversaries here in Florida. Could each of you comment whether these are being filed and litigated in your states and how that is going?
Yeah, go ahead. I gave my answer, so John.
I think they are on the rise. I don't know statistically whether or not there are more being filed. I'm in Tennessee, in Nashville. I don't know statistically if there are more being filed this year than in years past, but I can definitely see that is a likely trend upwards. And sort of as I was saying earlier, I think at least on the private side, there's a higher chance of settlement than actually going to trial than on the federal side. Natalie, your thoughts?
For me, I've been successful in settling the private ones. In fact, if I bring an adversary proceeding where it's sort of a mixed bag and you have government loans and private loans, depending on the balance of the private loan, initially from the outset, they won't even do discovery. I'll get, a call from, a private lender's attorney and say, we want to stipulate to the discharge and be dismissed from the case. And those are the best because then it's like, even though the case is still in litigation, I know that that's one less defendant to worry about. Usually if the balance for that particular loan is, somewhere in the $10,000 or $15,000 ballpark, and depending on how, compelling, I guess, the complaint is, and, even, like, they can just look at the debtor's schedules as well. Like, if the creditor's attorney can look and see, well, this is a pretty strong, undue hardship case, they're not going to waste the time to litigate it. So even when we're just dealing with the private lenders, I've had really good, like one of my best ones is I won't name the creditor, who the creditor is, but my client is in his early 30s. He had $120,000 of private student loan debt, just the private loans. And we were able to settle that after just a little bit of discovery for $40,000 at zero interest. So that was a big win. We didn't have to, go to trial or anything. There was not even a deposition. It was just the initial interrogatories and, production of documents. Recently, I've settled a couple. Especially the most recent one, the paperwork hasn't been signed off by the court yet, but I had two different adversaries, both private lenders who, are willing to settle. I settled one for 20% of the balance and one for 30% of the balance. And these are for educational loans that we were alleging weren't, in fact, educational loans. Just because you slap the student loan label on a loan doesn't mean that it is that. And the creditors realize that the burden of proof is on them, and they can't prove that this is, in fact, a qualified loan. One argument that the private lenders do try to make, though, is that the client signed, the promissory note said that you were going to use this loan for educational purposes. That's language that's sort of, I'd say just boilerplate buried in the actual contract. And, of course, these 18 and 19-year-olds are signing documents and not reading them. But they think, well, I'm a student, so I'm going to use this money and pay my rent and go on spring break or fix my car. And none of it actually went to the school or for educational purposes. But the lender will always try to argue that, well, they agreed that they would only use it for educational purposes. But even when they argue that, in their motion papers or whatever, and sometimes they'll file a motion. I had one creditor file a motion for summary judgment, and the judge denied it because, he didn't prove that the loan was an educational loan. Anyway, ended up settling that as well. But I think it's going well with the private loans, especially the ones that, if you allege that it wasn't used for educational purposes. So really like 20 or 30% of the balance, and not in one lump sum either, usually getting, 36-month payout or 60-month payout. So it's been going well on my end in New York.
Yeah, and I think that it's a good point that the private, if you can take the private out first, and that usually happens, then you can see what kind of payment plan you can make with the government one. And the government, I don't want to get into too many type horror story things in terms of how hard they are, but in the summary judgment motion on the good case with the 3 grandchildren, the debtor's daughter is the alternate guardian, and the attorney actually argued that the expense of having custody of these kids, and she'd had them their whole lives basically, was one that she voluntarily assumed. It wasn't a necessary living expense, and she could just let her daughter have custody of those kids, and then she would have more money available to pay on the student loans. So you're going to run into that type of thing. But when you have to, like I said, chopping away, even on these cases that Natalie has, if you can get rid of the private debt and settle the student loan debt on the private side, the government student loan debt may become manageable.
I had a question that sort of came up in both of y'all's presentations, dealing with situations where you're coming in after the fact, a couple years down the road, and are trying to mop up where the previous counsel or previously in the case you hadn't sought dischargeability. Have you found there's any sort of lower success rate, higher success rate coming in 2 years down the road, either reopening or just bringing the AP far later, arguing that there are new economic realities that weren't reflected in the schedules, or is it more or less still a case by case?
The only couple of things I have, in the 13th, it's kind of an ongoing situation. You may be 3 years into a Chapter 13, but you still have open case. The case I had was a couple of years later, and the change was she was able to come up with $1,500 to hire me. Her financial condition, she didn't have any medical or other change in circumstances. Bankruptcy. I have not handled a case where the reason for the undue hardship occurred after the bankruptcy case closed. Natalie has anything?
In my situation, even if I'm coming in 2 or 3 years later, the court always asks for the current situation as far as, in discovery, we're going to look at the current income, the current expenses, and sometimes it's pretty much the same. It may be slightly high, the income may be slightly higher. There may be a change of circumstance, like a medical condition that developed, in the last several years that wasn't there when the case was initially filed. So that would now have to, the debtor now has to budget for out-of-pocket medical expenses, for example, if they developed some sort of condition that requires, an expensive prescription or something like that. But typically it makes sense to look at the income and the at the time of trial. The trial that I wrapped up the trial the end of May, and we looked at it as if you would do the means test. We looked at the 6 months leading up to the trial date. So it was, doing the calculations, crunching the numbers of the debtor's pay stubs and looking at his expenses. So for the trial exhibits, we looked at his expenses in the last 6 months leading up to the trial. I personally think that makes the most sense, and I think the courts agree that we don't want to use a year-old or 2-year-old numbers. We want to look at the current reality.
Right. Have you had anywhere there was some event creating or adding to the hardship that was?
No, well, just the one case that I'm referring to where the debtor, he developed glaucoma, actually, in between the time that he initially filed his case and the time that the trial was happening. So that's an additional hardship. And also his child care expenses were increasing as well because he didn't have primary custody of his son, but he was taking on more responsibility, taking his son more often. So his child care expense increased a bit as well.
Let me ask both of you. In Detroit, I have a sense that the Chapter 13 trustees and the judges are weary of Brunner and think that it's too onerous and are loosening up in some areas as is available. Are either of you seeing that?
I mean, it's hard for me to say. I have a case right now that's like I'm on the edge of my seat waiting for the judge's decision, and I'm hopeful, I'm optimistic that he will rule in our favor. He's, and I say our because I'm like, I feel like my clients is, it's my case too. Like I take like personal ownership of it, but I think that it's trending that way, that they're looking at Brunner as this is a 30-year-old case, and everything that was true during that time is not true now, like the amount of debt that the borrowers owe, the time period of, how long the repayment periods last, it's just, and the fact that, during the time Brunner was decided, you could just automatically get a discharge if you just waited 5 years. And that's not the case now. So I'm optimistic. I mean, from the time I started doing this work 6 years ago, I'm like, oh, the change is right around the corner. It's right on the horizon. Any day now, Congress is going to fix this. Or, they're going to change the bankruptcy code. Something's going to happen. We're going to have a new case law that we look to instead of something that's 30 years old. But 6 years later, I'm still waiting. And I'm still optimistic, but I'm just like, this is taking forever. So,
John, have you seen any movement in the loosening up in the courts in your area?
I'm not sure. I mean, I think people, from my experience, I think that the trustee especially is just sort of accepts that Brunner is, begrudgingly or not, accepts that sort of that's the lay of the land as where things stand. And I mean, in representing creditors, I'm certainly not trying to rock that apple cart too much because I think it is definitely beneficial for our side, given the onerous standard that debtors have to meet. So,
I wanted to throw another resource out. I made a handwritten note. It seems that I don't think the government wants to appeal a lot of the decisions that are adverse against them because they don't want to make what they consider bad case law from higher courts. Of course, on the side of the street Natalie and I are on, the debtors don't have money for appeals. But former Judge Gene Weedoff from Chicago, who was the means test guy at the seminars for a while, fired, but he's doing pro bono appeals. Weedoff, W-E-D as in dog, O-F-F, and he has a passion on the loan issues. So if you run into one that you can find him or look through me. I think I could be able to track him down.
I'm not seeing any more questions.
Okay,
No, it looks like we have no more questions, so we will say thank you, and we hope you have enjoyed our national webinar, Discharging Student Loan Debt and Bankruptcy, Borrower and Creditor Perspectives, Bankruptcy Code Provisions, Educational Loan Types, Relevant Cases, Partial Discharge, Specialized Treatment in Chapters 7 and 13. If your question was not answered, you may email it directly to our presenters. Their email addresses are included in the presentation materials. If you're seeking continuing education credit, you must verify your participation in this webinar by completing and submitting the attendance affirmation evaluation after the program. A link to this form will be included in the thank you email that you will receive immediately following the program. As long as you have registered and paid for this program by 5 p.m. today, you will receive your certificate of attendance within 24 hours. If you have any questions about continuing education credit for this webinar, please call our Continuing Education Department at 404-881-1141, extension 2. Today's participants can order a recorded version of this event at a special attendee price. Please call customer service at 800-926-7926, extension 1, or visit Strafford's website at stratfordpub.com. If you're not yet a Strafford Annual Pass holder, try the CLE Individual Annual Pass. You can get all your CLE credits for one low price. Simply respond to the email you will receive after the program. I would like to thank you for your attendance. And this call, you simply hang up the phone. Thank you and goodbye.